How do you analyze the exclusionary rule and the fruit of the poisonous tree doctrine on a criminal procedure essay? Well, step one, up until this point in our criminal procedure video series, we've been talking all about what 4th, 5th, and 6th Amendment violations look like. We've talked about all the different ways that the government can violate a person's 4th, 5th, or 6th Amendment rights in a criminal procedure context. So now, in this video, we want to talk about what the actual effect of these violations are. We know what a 4th Amendment, a 5th Amendment, a 6th Amendment violation looks like, but what now happens to the evidence obtained as a result of that violation? Is that evidence going to be admissible or inadmissible? And to deal with this, we have the exclusionary rule and the fruit of the poisonous tree doctrine. And our starting point rule is actually really straightforward. Evidence obtained in violation of the 4th, 5th, or 6th Amendment, or as a result of the violation, is generally inadmissible unless one of these exceptions applies. We're going to talk about these exceptions, and it's worth noting that this isn't an all-inclusive list of exceptions, but these are the main exceptions you're going to see on a criminal procedure fact pattern, okay? But going back to our starting point rule, the key to recognize here is this idea of the fruit of the poisonous tree doctrine, which we have underlined right here. So, evidence obtained in violation of the 4th, 5th, or 6th Amendment is generally inadmissible, and everybody can see that very easily. But derivative evidence obtained as a result of the violation can also be inadmissible under the fruit of the poisonous tree doctrine. So what am I talking about here? Well, imagine that we have a typical, let's start with 4th Amendment. Let's say that we have a typical 4th Amendment violation. Let's say that a police officer goes to a person's home, the person's not there, so he just breaks down the door and starts looking around. Say he does not have a search warrant and no exception applies. So we have a clear unconstitutional search, clear 4th Amendment violation. And let's say while he's in the house, he finds all kinds of evidence. Let's say he finds a gun, a knife, a drug paraphernalia, or some other illegal documents, right? And he starts seizing all of this evidence. Well, in that example, what is the poisonous tree? If we're talking about the fruit of the poisonous tree doctrine, the poisonous tree is the 4th Amendment violation itself. So as you're reading a criminal procedure fact pattern, every time you see a government agent violate the 4th, 5th, or 6th Amendment, you should literally imagine a tree sprouting from the ground, right? A poisonous tree now sprouts from the ground. And whatever that tree is, right, is inadmissible. So that search itself is inadmissible under the exclusionary rule. But also any evidence obtained as a result of the violation under the fruit of the poisonous tree doctrine is also going to be inadmissible. So if he goes in and he finds a gun, a knife, drug paraphernalia, other illegal documents, all of that he's picking from the tree, all of those fruits, that illegal evidence that he's obtaining is also going to be inadmissible, right? It's a result of the violation. Now, unless an exception applies, but for the most part, our general starting point rule is that this evidence is also going to be inadmissible as fruit of the poisonous tree, right? Because these arrows represent the violation itself, poisoning the tree. Any evidence you pick from that poisonous tree, we're not talking about apples and oranges here, we're talking about guns, drug paraphernalia, other evidence of a crime is also going to be inadmissible. That evidence is tainted. It's coming from a poisonous tree. So imagine the violation itself as the tree and the evidence being picked from that violation as the tainted fruit of that original violation, okay? So in a 5th Amendment context, right, we could talk about this for any of the violations. 4th Amendment, it's really easy to see what that looks like, right? The original search is obviously our tree, and then all the evidence picked during that search is fruit of the poisonous tree and is also tainted. But just for one more example, imagine that we have an involuntary confession, right? The police hold a gun to someone's head and demand answers, and that person with a gun to their head tells the police that he committed a murder, and he tells the police where he hid the weapon, right? Well, let's say that the police go out and they actually find the murder weapon where this suspect told them it was located. Well, that involuntary confession is the tree sprouting from the ground, but it's poisoned, right? Because they held a gun to his head. So when they go out into one of those branches and pick that gun from the poisonous tree, right, it's also tainted. So the murder weapon is also inadmissible. So the confession itself is inadmissible. That's a Fifth Amendment violation. So evidence obtained in violation of the Fifth Amendment, that's clearly inadmissible. But also evidence obtained as a result of the violation. That's tainted fruit from the tree, right, which is going to be the murder weapon. Okay? So that's what your Fourth and Fifth Amendment violations are going to look like in terms of the exclusionary rule. The exclusionary rule is this first part of the rule, right? That's the direct evidence, the confession itself, or the search itself. The evidence obtained as a result of the violation is the fruit of the poisonous tree. This is derivative evidence obtained as a result of the violation, and that's also generally inadmissible under the fruit of the poisonous tree doctrine, okay? But now, all of this, though, is caveated, right? It's generally inadmissible unless, and then we have all these exceptions listed out. So let's talk about the exceptions starting with Miranda. So the key to recognize with Miranda is that the fruit of the poisonous tree doctrine does not apply. So a Miranda violation itself is inadmissible, right? If you imagine a Miranda violation as the tree is always inadmissible for substantive purposes, right? So the Miranda violation itself, whatever statements are made in violation of Miranda are going to be inadmissible for substantive purposes. But evidence obtained as a result of the Miranda violation generally are going to be admissible. That fruit is not going to be tainted because the fruit of the poisonous tree does not apply to Miranda violations, okay? So again, using the same example, imagine that a suspect is about to be given a custodial interrogation by the police, and the police forget to inform him of his Miranda rights, and then he confesses during that interrogation to a murder and tells the police where he's hidden the weapon. Well, in that situation, the confession itself is clearly inadmissible. That's the tree. Tree is always inadmissible. But the derivative evidence, if the police go out and find that murder weapon, even if it's where the suspect told them it was located, that's fruit of the poisonous tree. It's still going to be admissible, though, under Miranda, because the fruit of the poisonous tree doctrine does not apply to Miranda. So they can still use that derivative evidence. Fruit of the poisonous tree does not apply to Miranda. So when you're thinking about this tree, the tree, if this is a Miranda violation, if this is Miranda, then the tree doesn't have any branches. Imagine a tree that grows no fruit, right? To stick with this, you know, this example of this tree, this metaphor, imagine that the tree literally doesn't grow fruit if it's a Miranda violation, okay? It's a fruitless tree. The only thing that's inadmissible for Miranda is the trunk itself, right? Okay, so that's the main thing to recognize with Miranda. Moving on to this idea of an independent source, okay? So if the evidence is generally going to be considered inadmissible, one of our exceptions is going to be when there was an independent source to find the evidence. So imagine that there's another person who has told them. So you can, as always with these, you can choose any of the violations. So with this one, let's say that it's a Fifth Amendment violation. So let's say that the police are holding a gun to a suspect's head and they ask him where the murder weapon is hidden and he tells them the location. Well, imagine 2 seconds later, 2 minutes later, 10 minutes later, time doesn't really matter, somebody anonymously calls the police station and tells the police the exact same location as to where the murder weapon is hidden. Well, now they have an independent source that was lawful. So they have one unlawful source for the location of the weapon, but they also have a lawful source. Someone just called them and volunteered the information. Because they have an independent source that's lawful, that evidence is going to be admissible, right? There's an independent lawful source they can rely on to procure the evidence, okay? The next exception is an inevitability. If the police can show that they would have found the evidence inevitably, then it's going to be admissible. So even if you have a constitutional violation, you have a Fourth, Fifth, or Sixth Amendment violation, say you have an unlawful search, right? Police officer goes into the home, doesn't have a warrant, no exception applies, and he finds a, who knows, he finds, I guess actually one of the more classic examples would be a dead body, right? He goes in and there's a dead body on the ground. Excuse the macabre example, but this will illustrate the point well. right? So he goes in and he finds a dead body. Well, imagine that this was in a crowded apartment complex and it's an abandoned apartment, right? That body was going to be found whether that police officer broke in or not, right? A dead body is going to rot and decay. People are going to find that body. That body was an inevitability to being discovered. So it didn't really matter that that police officer violated this person's Fourth Amendment rights. He didn't have a search warrant and he conducted the search and no excuse applied because that body was going to be found no matter what. It was an inevitability. It's a crowded apartment complex. Someone's eventually going to smell that, investigate. The police were eventually going to find that. So if you can show that it was an inevitability that the evidence was going to be discovered, then it's going to be admissible. Attenuation is the same kind of idea as pause graph, right? You can think of this as the pause graph of criminal procedure. If there's attenuation in the causal chain, which is usually we're looking for an intervening cause, usually this is going to be the defendant's own free will. So imagine that we have a Fourth or Fifth Amendment violation. Let's say it's a Fifth Amendment violation. Police obtain an involuntary confession from the suspect, right? So they can't ever charge him with the crime because it was an involuntary confession. They don't really have much other evidence. So this person goes back out into the world. Let's say a year later, a year has passed, lots of events have happened in the causal chain from the original violation, and the defendant comes back on his own free will and confesses to the crime to the police, right? There's no involuntary confession. He has no reason to do this. It's his own free will. Well, we're not going to say that that's fruit of the poisonous tree at that point. There's enough attenuation in that causal chain. A year has passed and he's coming back on his own free will. So that confession is going to be admissible as long as it's otherwise lawful. There's no other violations happening, okay? Next, we have this idea of the police acting in good faith. So there's some situations where if the police are acting in good faith, we're going to allow that evidence to come in, even though there might be a minor violation involved. The main example here is where the police have a facially valid search warrant. In the Fourth Amendment context, the police have a facially valid search warrant, and they, in good faith, think they have a good search warrant, and they go and search a home, but it later turns out the search warrant was defective. In that situation, if they obtain evidence, we're going to say, yeah, there may have been a violation because the search warrant was defective, but we're not going to apply the exclusionary rule. That evidence is generally going to be admissible. Same idea here too. If the police are relying on a law that later that law becomes defunct or unconstitutional or whatever, if they believed in good faith that they were relying on a law and that law later becomes invalid, same idea, right? That evidence obtained is still going to be admissible. Also, similar to this, we have the knock and announce. Remember, to execute a search warrant properly under the Fourth Amendment, the police have to knock and announce before they enter the home. If they forget to do this, yes, technically, again, it's a violation, but because it's such a minor violation, we're not going to apply the exclusionary rule to that evidence, and we're going to say that it's generally admissible so long as there's no other violations going on. Finally, the last thing to recognize with the exclusionary rule is evidence being introduced for impeachment purposes. Now, this doesn't apply to involuntary confessions. Fifth Amendment involuntary confessions are not going to be able to come in for substantive purposes or impeachment purposes, but otherwise, if you have a Fourth Amendment violation or a Miranda violation, right? Not a Fifth Amendment violation. Fifth Amendment involuntary confessions can't come in for impeachment purposes. But again, if you have a Fourth Amendment violation or a Miranda violation, and then at trial the defendant takes the stand, you're going to be able to introduce that evidence not to prove the truth of the matter asserted, but to prove that, to attack the witness's credibility. So, you know, you can imagine this with a Miranda violation. If a confession is not allowed to come in because of a Miranda violation, right, it'd be very foolish for that defendant then to take the stand and subject himself to potentially being impeached, because if he says anything inconsistent with his confession, that confession was inadmissible because we had a Miranda violation. But if he takes the stand and he starts saying things that are inconsistent from that confession, then the prosecution is going to be allowed to bring that evidence in from that confession that was otherwise inadmissible to impeach his testimony. So just one last thing to look out for. What is the reason that this evidence is being introduced? And if it's being introduced for impeachment purposes, if the defendant takes the stand and gets up there and starts having inconsistent stories, even though it may have been inadmissible before, we might be able to bring it in now to impeach his credit or to attack that defendant witness's credibility. But I think that oh yeah, and also, one last thing to recognize is the harmless error rule. The harmless error rule basically says that if the defendant is convicted, I can just write this as one final note, harmless error rule. So if the defendant is convicted of a crime and later he wants to appeal saying, hey, one of my 4th, 5th, or 6th Amendment rights was violated by the government, if the government can show beyond a reasonable doubt that that violation was harmless, it would not have affected the outcome of the trial, then the judge is going to say, you're right, defendant, your rights may have been violated, but the result of the trial was going to be the same either way, and your conviction is not going to be overturned. So if the government, again, can show, okay, there was a violation, they're conceding that there was a 4th, 5th, or 6th Amendment violation, but it was harmless, and they can prove that beyond a reasonable doubt, then that conviction is not going to be overturned. That's the harmless error rule, and it's the last thing you want to note on a criminal procedure essay if you're dealing with a defendant challenging his conviction. But with that, guys, that's everything we need to know in criminal procedure for 4th, 5th, or 6th Amendment violations. Remember, number 1, you have to determine whether you actually have a violation. If you do, use this video, what we talked about today, to talk about what happens to that evidence obtained as a result of the violation. But with that, guys, I think that's everything we need to cover. I'll leave you to it. I wish you all the absolute best. Hope this was helpful, and I'll see you at our next video.